The Warren Court. So in 1954, you have the landmark Brown versus the Board of Education of Topeka, Kansas. In this decision, the separate but equal doctrine promulgated by Plessy versus Ferguson is scrapped. Separate but equal is no longer going to be the law of the land. The law of the land is going to insist on integrated school, institutional, and other facilities, and these integrations should happen sooner rather than later, and if they need to, they will happen by court order. So the integration of American schools is foretold and required, sorry about that, by the Brown versus Board of Education decision in 1954. And that leads to what happens in Little Rock, Arkansas 2 years later, which is a major part of the civil rights story in the United States. And that is the first of many landmark decisions of the Warren Court. The next is Mapp versus Ohio, 1961. Once again, you have a case where police acquire evidence without search warrants, and the police are engaging with the accused over different issues, and then they find evidence of another crime and arrest the people for the accused for that other crime. In other words, the police are there, they're talking to you about one thing, and suddenly, without a search warrant, they discover evidence of a completely different crime that they had no reason to suspect you of. They did not have reasonable suspicion, they did not have probable cause, and the exclusionary rule, which I will remind you of from the old decision way back when. Weeks versus the United States, 1914, says that evidence that is not obtained legally cannot be used in court. So, Mapp versus Ohio is going to make the job of the police much more difficult, and it's going to require them to operate much more close to what court orders allow. Engel versus Vitale, 1962. This is one of my personal favorites. Engel versus Vitale says that any school district that tries to set up a non-denominational prayer, in other words, a basic, broad-ranging Judeo-Christian prayer that is neither Catholic nor Protestant nor Reformed nor Orthodox, a prayer that simply references God, a prayer that students and teachers say at the beginning of every day, the kind of prayers that, having read some of them, I think would be wonderful in schools personally, because I'm a throwback. All of that is thrown out. The non-establishment clause in the Constitution says that the United States shall not establish a church. And that means that within very broad bounds, the United States should not play favorites in terms of religion. So the new interpretation of the Warren Court is that in a broadly Judeo-Christian society, which we certainly were in 1962, and which we sort of still are, but to a much lesser degree, even though that society's norms were much more traditional and Christian, it was considered to be a violation of the separation of church and state, which are words that never appear in the Constitution. Engel versus Vitale gets rid of school prayer. And ultimately is going to be used as a precedent to get rid of moments of silence and meditation and other things that deal with the spiritual side of life, which does exist, whether or not it's a religious thing or a philosophical thing, a Christian thing or a Buddhist thing or an agnostic thing. And there is a correlation between the decline of many schools and of many communities and the new Warren Court interpretation establishing a hard line between church and state, making it more difficult to teach values in the schools. Consider it. Come up with your own opinions. You've obviously been familiar with mine. Gideon versus Wainwright, 1963. You have the right to a public defender. A person who cannot afford a lawyer of their own will be provided a lawyer at taxpayer expense. They are not to be forced to defend themselves, which is something that's a very risky thing for anybody who's accused to do. Usually you want a professional lawyer. And if you are poor and can't afford one, Gideon versus Wainwright, 1963, the Supreme Court, I believe also in a unanimous decision, says that a public defender must be provided at taxpayer expense so that poor people have equal access to justice, at least more equal access to justice. In 1964, law is passed, which is the result of effort by everyone from the Reverend Dr. Martin Luther King to who would become Supreme Court Justice Thurgood Marshall, and it is the Civil Rights Act of 1964, which makes illegal overt discrimination within these United States on the basis of race. It is the promised land, in the sense that it is the end of Jim Crow and the end of so many overtly racial policies practiced by government and by private entities in our society. It is what people were going for all those years. But that very year, 1964, the year before I was born, the Heart of Atlanta Motel did not want to change its policies on what rooms were reserved for what kinds of people, and they considered the Civil Rights Act of '64 to be unconstitutional, and it was bumped right up to the Supreme Court, and the Supreme Court decided in favor of the government, and it deeply legitimized the Supreme Court, the Civil Rights Act of 1964, making it much more sturdy as a law, because the Supreme Court had very definitively backed it. Then we have Miranda versus Arizona, 1966. And in the case of Miranda versus Arizona, you have the genesis of something that you'll see if you watch cop shows. From when I was a little kid in the 1970s, I remember whenever a person is arrested, the cop or somebody will start saying, "You have the right to remain silent. You have the right to an attorney." Oh, wait. Oh, I can't believe I get this wrong. No. "You have the right to remain silent. Anything that you say can and will be used against you in a court of law. You have a right to an attorney. If you cannot afford an attorney will be provided for you. Do you understand these rights?" And basically, the Miranda rights are to assure everyone that people who are arrested within the United States understand that they are not at the mercy of the police, that they have a right not to answer questions until an attorney is present. And that's important for a variety of reasons. Now, people may choose to waive those rights if they're innocent, if they believe they're innocent, if they are trying to help the police. But when somebody says you are under arrest, you have a right to remain silent. That right, anything that you say can and will be used against you in a court of law, is to clarify that if you're under arrest, you are really taking a chance when you speak to the police and answer their questions without your lawyer being there. And again, a court-appointed attorney will be provided to you if you can't afford one yourself. This is called Miranda rights. And reading someone their Miranda rights has been a part of American law since the middle 1960s. Okay. Terry versus Ohio, 1968. The question of how the police gain evidence in trials has come up again and again in terms of the exclusionary rule. In the case of Weeks versus the U.S., and in the case of Mapp versus Ohio, the courts have said that the exclusionary rule says evidence obtained illegally. Well, what Terry versus Ohio does is it creates more balance. In the course of an investigation, the police come upon evidence that is tangentially related to why they've pulled these people over. This is taken to the Supreme Court. The defense attorney argues that the exclusionary rule says that the things that the police found should not be admissible in court, and therefore that his client should not be found guilty. But what the court says is, in cases where there is a reasonable suspicion, where the police have a reason to search and they have probable cause. For example, if you are driving wildly and the police stop you, they're going to search your car for booze or drugs. They're also going to invite you to take a sobriety test or 3, because they have probable cause to think that you may be intoxicated or under the influence, and therefore guilty of DWI, driving while intoxicated, or DUI, driving under the influence, or whatever it's called out here. That is probable cause. If you are running from the scene of a crime holding a television set, and the crime was a burglary, and the police spot you, they have a reason, they have a probable cause to search you, and to at least go through the process of seeing if you're running through the streets with a TV in the middle of the night has anything to do with the burglary of the TV store down the street. So, Terry versus Ohio clarifies that if the police do have probable cause, if they do have a reasonable suspicion, they can, in fact, search. And that, again, creates a bit more balance between the rights of the accused and the duty of society to protect itself against the bad people. Now, that is the end of the Warren Court. We will go on to the Berger Court and the Rehnquist Court next.